The year was 1953, and the machinery of surveillance had been set into motion across America. Under the banner of national security, intelligence agencies casted their nets wide, ensnaring not just suspected communists and activists, but also minority researchers and employees. Among those caught in this web was Annie Lee Moss, a Black civilian employee whose story would become emblematic of McCarthyism's reach into the lives of ordinary American citizens. In 1954, Moss found herself suspended from her job and hauled before Senator Joseph McCarthy's Permanent Subcommittee on Investigations. Much like my suspension from Queen's University Belfast and how I was made to undergo troubling disciplinary proceeding despite my adhering to the student charter and seeking external guidance on campus intimidation. It was also much like how Qian Xuesen, the Chinese aerospace engineer who made significant contributions to the field of aerodynamics. During the Red Scare, you see, the United States federal government accused him of communist sympathies, much how it did other people. His colleagues protested those allegations vigorously. Although McCarthy had no evidence to substantiate his claims against Xu Xian, he was stripped of his security clearance, much how Queen's University Belfast stripped me of my student clearance to the campus. But even as minorities like Moss and Xu Xian and myself faced the full weight of government surveillance, something remarkable happened. I'm Kiana Canada, and this is Mimicking McCarthyism. It's an examination of an obstruction of justice, understanding the Commission's immunity from action, and whether such immunity makes it reticent to investigate human rights violations. Welcome back. During the McCarthy era, human rights organizations were beginning to push back, and they did so vigorously, laying the groundwork for protections that would eventually challenge such unchecked governmental power. The question that emerges from this history that remains stuck in our minds is, and of course, one that reverberates through the corridors of institutions like the Commission today, is whether those tasked with protecting human rights can truly fulfill their mandate when they themselves are immune from civil and criminal liability. You see, this protection enshrined in legislation and international standards serves a critical function. It shields commissioners from prosecution by hostile government officials, including the Police Service of Northern Ireland and intelligence agencies operating within the United Kingdom. Under the Paris Principles, which we've been talking about throughout this series, this immunity is not merely administrative convenience, but a fundamental safeguard. Like diplomats, commission members and their staff are held inviolable and immune from search, seizure, requisition, confiscation, or any other form of interference in their archives, files, documents, communications, property, funds, and assets. This protection ensures that they can gather and maintain evidence without fear of retaliation. And what it also does is it creates a buffer between human rights work and state interference. So, why doesn't the Commission investigate the government more. Blanket immunity can foster an environment where the Commission purposefully refuses to take on cases, knowing victims suffering from human rights violations, such as minorities like myself, are unable and have no other legal avenues to hold it accountable. Consider how the immunity allows the Commission to watch state agents violate human rights from the glass door of its institution, choosing not to open the door to intervene, but choosing just to watch, because there will be no consequences if it doesn't. The protection meant to enable bold action becomes underground shelter for itself. This institutional insulation fails victims most profoundly, particularly Black Americans in Northern Ireland, who find themselves subjected to transnational repression. Immunity that has once enabled the Commission to stand against government abuse has now become the mechanism by which it can ignore the abuse without consequence. That's something to ponder on. Yet, immunity does serve a crucial protective function that cannot be dismissed. Most fundamentally, the Commission cannot be imprisoned if they make findings that a state agent has engaged in a state crime. This protection, ladies and gentlemen, is vital in Belfast, where intelligence agencies and services operate with broad powers and where challenging state security apparatuses require institutional courage backed by legal safeguards. State agents, as you will understand, cannot sue the Commission for defamation. And it can't sue the Commission if the Commission criticizes intelligence agencies engaged in domestic or transnational repression. This immunity from civil liability enables the Commission to speak truth to power, as it should have done in my particular case. The protection also extends beyond mere criticism to encompass the publications of findings, recommendations, and reports that might otherwise trigger defamation claims from those in positions of power. To reiterate, the Commission staff are like diplomats. This diplomatic style immunity is not ceremonial, but practical. But what happens when the Commission waives its diplomatic rights and aids state agents in the seizure of testimonies and supporting documents regarding the state's involvement in crimes? While the Commission may argue it has never handed over documents to state agents, and I'm sure it will argue that, when the Commission demands that victims undergoing state-sponsored surveillance communicate exclusively via email, as it has done in my particular case, this very medium most susceptible to interception, and it is most susceptible to manipulation. And what it does is it raises a profound question about complicity. You see, intelligence agencies possess sophisticated capabilities to monitor, and not only to monitor, but to intercept communications on transmission, where they can, as they have done in the cases of multiple journalists, alter those communications and resubmit it as if it had never been intercepted in the first place. Intelligence agencies can also deploy spyware like Pegasus to gain complete access to the device, monitor email surveillance, and track online movements. This is irrespective of whether the person poses a threat to national security. In most instances, they don't. Let me be clear. When state agents had me injected from the university, they were not investigating a threat. They were conjuring them, begging for something, anything, to appear so that they could engage in actions more harmful than expelling me from the program. Why didn't the commission intervene is what I want to know. And it's something that you should know as well. Because, you see, the Paris principles are unequivocal. The commission cannot maintain its accreditation as a legitimate Northern national human rights institution if it functions merely as a local institution addressing only Irish cases in Northern Ireland. Such parochialism would violate the core principle that human rights must transcend ethnic and racial boundaries. The Commission's compliance with international standards further depends not on tradition and orthodoxy, but on its willingness to address human rights violations wherever they occur within its jurisdiction. And this is regardless of the victim's background and the perpetrators involved. Moreover, and I want you to know this, any restriction or exclusion from the Commission's mandate raises concerns about its compliance with the Paris principles. It really does. While the Commission may lack the capacity to review the actions of state security services or intelligence agencies, and I'm not saying that it can do that, I'm acknowledging that it possibly cannot, the Commission definitely possesses the power to bring public attention to their activities. To be sure, under articles of the European Convention on Human Rights, the Commission not only has the authority, but the obligation to investigate, identify, and remedy human rights violations in Northern Ireland. Further, the Commission's reliance on the European Court, the European Convention on Human Rights, further provides it robust tools to address transnational repression. Most critically, it enables the Commission to investigate and identify violations that are immediate or proximate risk of occurring and implement measures to prevent them. This is the epitome of a national human rights institution. Yet the Commission has not harnessed this function. This institutional failure represents more than administrative oversight. It constitutes a betrayal of the Commission's core mandate and, not only that, ladies and gentlemen, a violation of the trust placed in it by those most in need of its protection. The Commission's inaction becomes particularly egregious when viewed against this backdrop of its legal obligations and institutional capabilities. When the Commission systematically excluded me and the complaint I made from its purview, and possibly done that to others, it failed the basic test of institutional legitimacy. The Commission has a duty to protect it has a duty to publicize the demagoguery of the McCarthyites operating in Northern Ireland today. Agencies who are using the McCarthyist playbook to interfere with my educational pursuits or the educational pursuits of others in similar situations, and to oppress me because I have chosen to end my relationships with the United States, is concerning. The Commission must recognize that its immunity from prosecution was never intended for it to be an altar by which it sacrifices victims. Its immunity was intended to prevent victims, like myself, from becoming the proverbial sacrificial lamb. Ladies and gentlemen, on Wednesday, what we're going to be doing is we'll be examining the Commission's capacity to provide advice on inquiry and why it should hold a comprehensive investigation into transnational repression in Northern Ireland. We will also explore why the Commission's advisory powers should be leveraged to address the political intimidation I experienced on the island. There is a book that I'm reading from, and before we get into that, the question is not whether the Commission can act, but whether it will choose to act. There's the book that I'm reading from here. It is Demagogue. It's called Demagogue, The Lone Life and Long Shadow of Senator Joseph McCarthy. Is by Larry Ty. This is what I've been basing this series on, and I hope you're enjoying it. If you have questions, feel free to reach out to me, and hopefully we'll be wrapping the series up next week if no other information comes out, but we'll talk to you next time. Bye-bye.